Good evening, sir. This is Rochelle Cardente, and this is my final examination for CLJ 400, Section B, where we are given a questions to answer. Question number 1. Define evidence and explain its scope. Evidence is the means sanctioned by these rules of ascertaining in the judicial proceeding the truth respecting to a matter of fact, and the scope is the rules of evidence shall be the same in all courts and in all trials and hearings, except as otherwise provided by law or by these rules. Question number 2. What are the three kinds of evidence? Explain it briefly. The three kinds of evidence are namely object evidence, documentary evidence, and testimonial evidence. In object evidence, it is an evidence are those addressed to the sense of the court, which when an object is relevant to the fact in issue. And then in documentary evidence, it is an evidence consists of writing, recording, photographs, and other materials containing a letter and words, sounds, figures, symbols, and their equivalents and other forms of written expression offered in the court as a proof of their contents. While testimonial evidence is a witness can testify only to those facts he or she knows of his or her perception or her own knowledge, personal knowledge. While question number 2 is distinguished corroborative evidence to cumulative evidence. In corroborative evidence it is an additional evidence of a different kinds of and characters tending to prove the same point, while in cumulative evidence it is an additional evidence of the same kind and character tending to prove the same point. And in question number 4, which is what is prima facie evidence? Prima facie evidence is evidence which, if unexplained or uncontradicted, it is sufficient to sustain judgment in favor of the issue it supports. Well, question number 5, which is what is a dying declaration? The dying declaration of a dying person the dying declaration is that the declaration of a dying person made under the consciousness of an impending death may be received in any case wherein his or her death is a subject for inquiry as evidence of the cause on surrounding circumstances of such death. While question number 6 is what about statements uttered as part of res gestae? In res gestae, statement made by a person while a certain occurrence is taking place, or immediate prior and subsequent thereto, under the stress of a subsequent caused by the occurrence of the respect to the with respect to the circumstances thereof, may be given in evidence as part of the res gestae. And then question number 7, what is the order of an examination of an individual witnesses? Briefly explain or briefly define each. The order of the examination of the witnesses are as followed. First, direct examination by the proponent. Second, cross-examination by the opponent. Third is redirect examination by the proponent. And lastly, the cross-examination by the opponent. In direct examination, it is the examination in chief of the witnesses by the party presenting him or her on the fact relevant to the issue. In the cross-examination, upon the termination of the direct examination, we may be cross-examined by the adverse party of any relevant matters, with sufficient fulfillment and freedom to test his or her accuracy of truthfulness of her and freedom of the interest or bias, or the reverse of the and to the illicit of all important fact bearing upon the issue. And then in a redirect examination, after the cross examination of the witness has been conclude, he or she may be re-examined by the party calling him or her to explain and supplement his or her answer given during the cross-examination. On the redirect examination, questions on the matter of not dealt with during the cross-examination may be allowed by the court in its discretion. While lastly, in cross-examination, upon the conclusion of the redirect examination, the adverse party may be cross-examined the witness on the matter of state of his on matters stated in his or her redirect examination, and also on such other matters as may be allowed by the court as in its discretion. While in question number 7, briefly explain what is a judicial affidavit. Judicial affidavit is a statement a witness given under oath intended to take the place of the testimony in a court given during the direct examination. While question number 8 is an offer of compromise in criminal case is an implied admission of guilt. What are the two exemptions? The two exemptions are in quasi offense or acts defined and penalized under the Article 365 of the Revised Penal Code. And then number 2 is those allowed by the law to be compromised. And then question number 9 is in order for evidence to be admissible, it must be relevant and competent. When is evidence relevant? Evidence is relevant if it has a relationship to the fact of issue, as to induce belief in its existence and non-existence. Well, when is the evidence competent? Evidence is competent if it is not excluded by the law or this or on these rules. While question number 10 is what is the leading question and what when it is allowed, what is a misleading question? A leading question is a question which suggests to where it is a question when suggests to the witness to answer which examining party desire. It is a leading question. When it is allowed on cross-examination, on preliminary matters, when there is a difficulty of getting direct and intelligible answer from a witness who is ignorant, or a child of the tender years, or is a feeble-minded, or a deaf mute, or in unwilling or hostile witness, or of an witness who is an adverse party of or an officer, a director, or managing agent of a public or private corporation or a partnership in an association which an adverse party. Misleading question is when assumes as true as a fact not yet testified to be by the witness, or a contrary that which he or she previously stated. Question number 11. When is the circumstantial sufficient to sustain conclusion? Rule 133, Section 4, circumstantial evidence is sufficient to sustain if there is more than one circumstances. The fact from which the inference are derived from are proven, and the combination of all circumstances is such as to produce a conviction beyond reasonable doubt. Then, distinguished burden of proof from burden of evidence. In burden of proof, it is the duty of a party to present evidence on the fact and issue necessary to establish his or her claim or defense by the amount of evidence required by law. In a burden of proof, it never shifts. While in burden of evidence, it is the duty of a party to present evidence sufficient to the establishment or rebut a fact in issue to establish a prima facie case. Burden of evidence may shift from one party to other in the course of the proceeding depending on the exigencies of the case. What are the standard of proof necessary in civil case, criminal case, and administrative case? In criminal case, the accused is entitled to an acquittal unless his or her guilt is shown beyond reasonable doubt. While in civil case, the party having a burden of proof must establish her or her by a preponderance of evidence or superior weight of evidence. While in administrative case, a fact may be deemed established if it is supported by the substantial evidence. Question number 14. Define public documents. Public documents are admissible in evidence without a needs of proof for proof of their due execution and genuineness. How do you prove and present to in court private document? Before any private documents offered as authentic is received in evidence, it is due if its due execution and authenticity must be proved by any of the following means. The execution must be proved by any of the following means: by anyone who saw the document execute or written, by evidence of the genuineness of the signature and handwritten of the maker, and by the evidence showing its due execution and authenticity. Then 16 is the original document rules. Original document rules state when presenting a document evidence, only the original is admissible. What are the four exemptions? The four exemptions are: the original document is lost or destroyed or cannot be produced in court. And number 2, the original document is in the custody of the adverse party or under the control of the party against whom the evidence is offered, and the later failed to produce it if after reasonable notice or the original cannot be obtained by local judicial process or procedures. Third is the original document consists a numerous account on the other documents which cannot be examined in court without great loss of the time, and the fact sought to examine establish the fact is only general result of the whole. And lastly, the original document is a public record. All person who can perceive and perceiving can make known their perception to other may become a witness. Then last question is when is the extrajudicial confession sufficient to sustain conviction? An extrajudicial confession can be sufficient to sustain a conviction when it is created with evidence of corpus delicti. And that would be all, sir. Thank you.